you. Good morning. May it please the court. I am Bill Gressley from Jacksonville on behalf of the appellant Catherine Duhamel. I would like to reserve 5 minutes for rebuttal.
Sure.
And I'm looking to see where the clock is. I apologize, but I don't see the clock on my screen. Maybe I'm not.
Well, wait, there's not a Zoom clock. I will try to give you a heads up when you get to the 15-minute mark, and
Okay.
you might, take your watch or something and lay it beside your keyboard. And
I can do that. Sorry. The last time I did a Zoom, there was a running clock somewhere.
yeah, not on ours. Yeah, that's when I practice. I would we didn't have Zoom, of course, and I would walk to the podium and I would take my watch and lay it on the podium next to my notes so that I could follow it. But
My watch is on my iPhone, Judge, but I do
well,
stopwatch, so that works.
Okay, you're up.
I'll do my best. It's an aspirational goal to have some rebuttal time. Your Honors, this case has more tentacles, I think, than any case I've ever dealt with. And that makes it a challenging effort for both the lawyers and the judges and your law clerks. The first issue that I think needs to be addressed is, regardless of anything else, the inadequacy of the alimony and the equitable distribution issues I will get to as I can. But the first order of business is whether the award of alimony, even if it stays unchanged, should be taxable to my client. And I say that the law says no. This is not a 2018 final judgment, as has been found by the final judgment that's under review. And it's not extended by a nunc-pro-tunc order in January of 2019, as argued in the answer brief. This gets to be tautological. The opposing counsel has pointed out that, well, as long as, under my theory, that as long as an appeal keeps happening in a case, then we'll never have a final judgment. And technically that's accurate. And that's the dispositive element for the issue presented here, which is that there has been no final adjudication of the party's marriage. And by that, I don't mean that the court below did not dissolve the marriage, but the issues of equitable distribution and alimony, all of those issues are still pending. And even if you ignore that we still have ongoing proceedings, nunc-pro-tunc is legally improper. That the case that Taneja, T-A-N-E-J-A, that was filed by opposing counsel as supplemental authority on this issue is not only factually inapposite, but it's legally irrelevant. That case dealt with a reversal of a claim against a personal guarantee, and after the remand, the trial court allowed the creditor to assert a claim for individual liability against the same person that the guarantee was found to be not enforceable. This court, on a motion to enforce mandate, said you can't do that. That's an improper way to deal with the case. That has nothing to do with nunc-pro-tunc. The nunc-pro-tunc was done in this case in January of 2019 in order to allow the court to consider an attorney's charging fee claim. And that's a brand new issue. The cases cited in the reply brief addressing this issue demonstrate that that's not a proper use of nunc-pro-tunc. So under any circumstances, the alimony award should not be taxable to my client.
Well, I do want to ask one question about something you just said, because you seem to be taking the position that your clients were divorced, the marriage was dissolved as a result of the earlier judgment. I'm a little concerned about that because the appeal opinion in the earlier case doesn't say what we typically say, which is that we do not undo the dissolution of marriage. It outright reverses the final judgment of dissolution.
Exactly. And what I said, and I didn't mean to interrupt, Judge, but what I thought I said and what I meant to say was, even if you assumed that it dissolved the marriage, it's still not final. And that's the dispositive legal question for whether the alimony award should be taxable to my client. I thought about this, what you just said, that I need to remember, because I do nothing but appellate work and almost all of it in family law cases, to stay focused on that. Because the husband testified at the most recent hearing in 2022 that he used that final judgment to fill in whatever forms he needed to for removing my client from his health insurance. And I thought to myself, well, if they accepted it, and perhaps that can be a potential use of that. But the final judgment's reversal, and I've cited the seminal case, which I can't remember, but it's cited in my brief, that just says once you've set aside an order or final judgment, the case returns to the trial court in the position it was in before you took the appeal.
Well, and if either of the parties have since remarried, which may not be the case here, the nunc-pro-tunc language might be really important, regardless of what it impacts, whether it impacts the alimony award otherwise. But anyway, I just was concerned about that.
I agree, and I agree that this issue has opened a number of interesting issues. But the point of my argument, and what the only real legal issue here, is whether or not it is a final enough order to be considered taxable to my client, and the answer to that is no.
And I don't want to take up all the time on the taxable nature issue, but if that were to be the only point we found had merit for reversal, on remand, the only thing that would need to be happen is amending the final judgment to change the tax nature of the award, correct? Assuming you don't win on anything else. I'm not saying
Yes.
you will or won't.
That's correct. I have
Okay.
to acknowledge that needs to be done no matter what.
Okay.
But there's other things that need to happen, because there's
I understand, and you certainly can
multiple
go
grounds for
forward with that.
reversal, Judge. Excuse me. And where to start? I think one of the components that it ties into this that's important for purposes of my client's alimony claim is the amount of support of $2,500 a month, even assuming we don't take any taxes out of that, is not only facially inadequate, but when you look at the husband making over $200,000 a year, and my client in a almost 29-year marriage never worked outside the home and has no source of income, it's on its face inadequate. One of the things that is really troublesome to me and to my client, obviously, is that the alimony award provided no health insurance for my client. And one thing I'm loath to say I'm positive about much of anything especially when I'm making a legal argument, but I'm positive that she's going to have more than zero costs for some kind of health insurance. The final judgment claims that my client put on no evidence of the cost of health insurance, and that's not only incorrect in contrary to the record, but it's also disingenuous. The temporary order on attorney's fees, et cetera, and I've cited it on page 5 of my reply brief, quoted this section, found that the husband was incurring a cost of $417.12 per month for my client's health insurance under the temporary order. Well, that wasn't a made-up figure. That figure had been found by the magistrate early on the temporary needs order, based on his pay stub, which was introduced into evidence and made part of the record. And so if you remember, we had proceedings in 2018, which the court's reversal in the last appeal sent it back to receive evidence from my client, which is the most current issues. And at the most current hearing, she tried to put on evidence based upon two things: the former husband's pay stub, which was in evidence, that showed how much money he was spending for health insurance, including hers, and it was like $1,900 a month, but the husband couldn't clarify whether that was covering one of the minor children plus her plus him. But the important part of this is she tried to put in a document produced by the husband, in which trial counsel for the husband had stipulated that all of these documents could come into evidence without authentication. And it was the state of New York Civil Service documents about COBRA coverage, because my client asked for COBRA coverage. She wanted to ensure that she had the same kind of health care as she had during the marriage. And this judge said, no, I'm not listening. That's hearsay. And when my client, and so much of this case is less than straight lines and short proceedings, is because my client was acting pro se.
One of the issues that I noticed is on her financial affidavit that's in the record, she had listed under health insurance, currently on Medi-Cal, low-income insurance at no cost, and she repeats that several times. What was that all about in terms of what the trial court? The trial court could be focused on the fact that she says she doesn't have a need for health insurance.
Judge, I have no answer for that because that was not part of any testimony that I'm aware of. And I know that she continually tried to get some coverage. If there is, I don't know what the answer to that is, because
so much of the difficulty in this case, and you have alluded to it, or maybe you've actually been pretty direct about it. There's lots of lines going in all sorts of directions. And one of the things that has concerned me as I went through this is repeatedly the trial court found that your client lacked credibility, changed her position. She was pro se, which, as you know, doesn't protect your client a whole lot. And so we're left with what appears to be a bit of a mishmash of a final judgment. There's a clear discrepancy in income. The former husband put on evidence as far as his expenses, which the trial court accepted, and the trial court rejected your client's claim of additional expenses that were not awarded. So I'm struggling with how we deal with this when we have a record that your client didn't really perfect for us in terms of evidence that was presented.
Judge, as her appellate counsel, all I can say is I understand that concern. I have it too, and it's difficult to sort out in all of these various tentacles what's got legal traction, not only in terms of what's a legitimate appellate argument, but what really ought to happen in this case, because we're told from Kanakaris on that you're not supposed to let one spouse pass from prosperity to misfortune. And looks like I've got 5 minutes left in my major portion here, if that's correct, Judge Northcutt. I don't know.
I show that you have about 8 minutes left. So
okay, so I got 3.
Go crazy, Mr.
Grassley. People that know me would say that that's a constant.
Yeah.
My next real issue and they're all legitimate issues that deserve consideration. My client has been financially dependent on the husband for 19 years. The idea that they live beyond their means and that she handled the finances, those are without a factual basis. She paid the bills. He got paid twice a month. The only use of the overdraft until they had 3 sons in college at the same time was she would write the bills for with the first paycheck and pay them. And some of them would come due and get paid before the second paycheck would hit. It would go to the overdraft card that they had to make sure that no checks bounced. And then they would, as soon as the next paycheck would come in, it would pay the overdraft card. And as long as you paid it within 30 days, there was no interest charge. So this wasn't a question.
Is that undisputed, Mr. Grassley, that's how they did it?
I did not see anything, and Judge, I'm very cautious about saying undisputed because the way this has happened, but I did not see any testimony from the husband that said anything to the contrary. This was my client's testimony, the pages of the record that occurs, I've got in my brief. But the bottom line is that these parties owned a house in Nebraska, a house in Canada. They rented an apartment for her in Florida and an apartment for him in New York. They put a son through Harvard, a son through, I can't remember, another Ivy League school. Thank you. And the youngest went to UCF. But they managed to do well and put up retirement funds. I would be remiss if I didn't talk about the disparity between the trial court's treatment of the 2019, yes, I want to say 2019. I hope that's the correct date, not 2009. Sorry, I got to make sure I know that. February 2013, and the other's 2009. The 2009 marital agreement, which is an attachment to the final judgment, has the parties agreeing that all appreciation on any of their accounts and retirement assets belong equally to them. And the judge here has decided, well, I had to go back and do this again, so I'm going to use the date of filing. And this judge clearly punished my client. And that's a strong word, but he disfavored every one of her arguments, and this one has a serious financial impact. The briefs have discussed and cleared the fact that this 2013 agreement, which she found was not enforceable because it was the product of duress, I don't think has any factual basis. The parties were definitely both concerned. They were in the middle of a breakup of their marriage, but they agreed to this after 4 days of negotiation. This was not there. You can't look at this record, in my estimation, Your Honors, and say that neither party had free will. They were both in hard places, and they both decided that this was something that they would do.
And Mr. Grassley, you are now in the 5 minutes left situation. So do as you please.
Give me 20 more minutes. That's what I would please. But no, I'll save my rest of my time for rebuttal, Judge.
All right. You got it. All right, Ms. Thompson, you're up.
Yes, good morning, Your Honors. Deborah Thompson for the appellant Gerald Duhamel. May it please the court. I do agree with Mr. Grizzly about this case. It does have a lot of tentacles. However, I think that's where our agreement stops. I'll start out with the issue of the law and the tax applicability. And you know, one thing that I've noticed, and in the cases that he cited and in my own research, I can't find a single dissolution of marriage case that addresses this particular issue. I found some other cases, and there's been others that Mr. Gristle cites, but and that to me was in and of itself interesting, because just in my brief, the logical argument is if it is the dissolution, he's saying they're still not married, or they're still not divorced. But you know, the only change in that initial amendment to the non-protunct order was reflecting the prior ruling that just was not put in the final judgment, stating that reflecting the attorney's lien charges, and that reservation was reserved. Nothing was changed in that amended final judgment, in that initial one. My interpretation is, you know, any divorce or separation instrument executed after December 31st, 2018. So in here we have, when we look back into, even in the amended and the most recent final judgment, we've got this alimony award that still starts prior to this date. So it's logically would make sense that that's going to be the law in place if that's when the alimony is starting. And
that might be how the parties acted, but our prior opinion outright reversed the final judgment.
Yes, I understand that, Your Honor, but it was just so that former wife, Ms. Duhamel, could present her additional testimony that she was not allowed. It was very limited in its scope. But
how would you respond to the suggestion that we're better to have a clear red line in these situations?
Well, I think the best thing that would probably,
rather than having to go examine, you know, every judgment and every appellate ruling to decide, you know, when this new whether this new IRS situation applies.
Right. I think that, I mean, from a logical or from a practical standpoint, maybe instructions even to the trial court to make specifically known, what law is being applied or what is the date. Because the problem here, and I'm sure this is not the only case you guys are dealing with this issue, but is that everything was happening prior to 2018. I understand that there's additional testimony that was happening, but even that additional testimony is from activities prior to this date. It's not about other things that have happened after. So really, I mean, the final judgment has to do with everything that happened prior to this date. So, so that's kind of, I mean, I guess my point on that. With regard to the amount of that was awarded to Ms. Duhamel, I know it was noted that Mr. Duhamel's gross income, but gross income is not first what is used to determine alimony. It's going to be net income, and there is no gross disparity. And even if there is a significant difference, the case law even says specifically that standard of living is just one factor, and it's not appropriate where the parties live beyond their means. And the trial court specifically found, after witnessing the witnesses and hearing all the evidence, that they live beyond their means. Whether or not anybody disagrees with it, that's what the trial court found, because they had lack of luxuries. They overdrafted their accounts. There's testimony about they both drove old vehicles. They didn't attend. They attended public school. Yes, their children went on to highly esteemed colleges, but public schools, they all went to public schools. That this was not a family that was rolling in the dough. So, he took on, and this is a big part that was left out too. The trial court made mention, and it was very important to note that in its equitable distribution scheme, Mr. Duhamel took on $56,000 plus more of debt, and that was a big part. It was a part of the trial court's decision on alimony as well, because that's also going to impact his ability to pay. And he had testified that he couldn't afford more than $2,500 to begin with. While we did not, I'm going to get into just the retroactive. So just to preempt, I guess, with Mr. Grutzel when he gets to it. With the retroactive support being denied, it's all in my brief. I just wanted to point out that, again, the trial court found that he was over supporting her during this time. She had been receiving $2,300 a month from her mother, which she failed to put in her financial affidavit. There's a lot more to it based on the fact that, yes, Judge Silberman, you were correct that the trial court found numerous times that she just was not a credible witness. The court found that they thought that she coached her kids in her testimony. It's all throughout the record on reasons why they found her not to be credible.
Let's go back for one moment to the mothers providing some financial assistance, and I think there was also some evidence that that the son was providing her some financial assistance. Is that properly taken into account, absent some showing of a long-term agreement that mom would continue supporting her?
Are you saying that should she have put that on her financial affidavit, or are you saying in reference to
should the trial court have taken that into account when it appeared to be, at least on paper, helping her get through everything during the divorce?
Absolutely it should, because that's income coming in, and if she's getting that additional $2,300, then that's going to impact what her need is.
But doesn't there have to be some sort of evidence, or at least perhaps a finding even that this income, these gifts will continue, as opposed to, as Judge Silberman suggests, helping her out because she was having trouble making ends meet during the divorce litigation?
I think if we're talking about prospective alimony, absolutely. But here, for this argument, we're talking about retroactive alimony and the support that she should or should not have been receiving prior to. The trial court denied her retroactive alimony because that was part of it. In addition to the surplus that he was paying her each month, and then his payments toward her credit cards, the alimony payments that he was giving her, the debt that he had been assigned, all the expenses that were right in the record on page on 712 in the final judgment. It lists specifically why the retroactive support was denied. As far as the health insurance issue, it is not the former husband's job to present evidence to the court as far as what her health insurance is. He mentioned the temporary order that she had said something about the cost of insurance at that point and about his pay stubs at that point. But we're not talking about a temporary order. And many times, even throughout this hearing, as you'll see in the transcript, she kept trying to refer to it. But we're talking about the final hearing now and what was presented there. The evidence that was presented at the final hearing was former husband said that health insurance she could probably get between $86 and $250 a month. That was it. It was undisputed. Former wife did not say anything or even dispute. So that was what the court went with. The court just is not cannot just pick numbers by herself if it's not presented. In addition to what her financial affidavit said, as Judge Silberman pointed out. And I also wanted to point out that she was not pro se this whole time. Ms. Duhamel had numerous attorneys throughout all of these proceedings and throughout the numerous appellate proceedings that she had, to the extent that that's why we had to deal with the charging liens, which I believe there were 3 of them that were eventually all released, the charging liens against her. The equitable distribution in the 2009 agreement, yes, Mr. Gracely is correct that the agreement does say that their assets should be split, but the issue is the determination of where the court values these assets and liabilities. And pursuant to the statute 61075, the judge may value different assets at different dates based on the judge's discretion. Here, the judge decided that the retirement account will be valued at one date earlier, and then the other one would be later. The court used 2015 for retirement, used 2018 for credit cards and loans because the parties continued to use them during the pendency and stated lived beyond their means. It is not the court's duty to come up with an amount for appreciation that former wife claimed to not receive. She said she wanted to get her share of future appreciation, but there was no amount, and plus the court picked an earlier date. Even though I know former wife argued the case of Byers v. Byers, where the parties put the proceedings on hold when the husband went into rehab and disability, and the accounts passively appreciated. The trial court said that this was very different because of wife's delay tactics. When she filed numerous appeals that she testified that she knew she couldn't win, but she filed them anyway. And then she shouldn't be able to benefit from this. And this is one of the reasons why the court valued it at 2015 instead of 2018. With regard to the 2013 paperwork, the burden here is on the party seeking judgment on the basis of compromise to establish assent. And yes, this was a very difficult time for the 2 of them, but even Ms. Duhamel admitted she never expected him to follow through. She knew that he was only signing in order to get this household that had been under contract for over 3 years. She testified she believed it was written with the intent not to honor it. And this is a factual decision for the trial court. It's a factual decision to determine if there was a meeting of the minds. And there's no abuse of discretion here, is that it's been supported by competent substantial evidence, as addressed as well in my brief. Finally, as far as the dissipation claim, that is fully addressed in my brief as well. But just want to point out that even though that their equitable distribution typically is going to be even, there's an exception when there's misconduct during proceedings that results in dissipation. And in such a case, that serves as a basis for assigning a dissipated asset to the spending spouse. And that's Roth v. Roth 973-580. And that's a second DCA case. The trial court was very specific, especially the second time around after remand, in making very clear the reasons for her decision in anticipation that this may be appealed, and went through line after line after line of Ms. Duhamel's intentional misconduct.
Let me ask you a question, Ms. Thompson, about the passive appreciation question. And you said that the judge chose a valuation date in order to deny her share of passive appreciation because of her extending the proceedings with frivolous appeals.
No, I said that the judge is permitted to choose either any valuation date. And
yeah, but not arbitrarily.
Correct, but I think
there had to be a reason.
Well, based on the fact that it was that she distinguished it from the Byers case, yes, that would lead me to believe that that is part of the reason.
So she did it because she said the wife should not benefit.
Correct. From her delay.
How is it a benefit to the wife? There's passive appreciation. It just is. And so if she extended or didn't extend, so if she had received her share of those assets and then had passive appreciation, it would have been hers. It didn't affect the husband at all, right? Because he's still going to get his share of the passive appreciation, whether the case goes quickly or not.
Yes. Is
it possible that the judge's rationale was irrational?
Well, I suppose it's possible, but I don't believe it was, because she was, she witnessed the parties the entire time. And
yeah, the only thing that I could conclude in terms of a rationale is that was intended somehow to be a punishment.
No, I understand your the concern there, but
that does concern me, because there's a long history of case law that says you can't deprive someone of a property interest as a punishment or as a sanction.
Well, I mean, Your Honor, I can't specifically say why that she did that. I can just tell you that that she did differentiate between Byers and this case. So but at the same time, even though former wife is arguing that she did not get her future appreciation, she didn't present any evidence showing that she should be entitled with anything, and it's not the court's duty to come up with that amount.
Well, I mean, what the argument here is that the choice of the valuation date deprived her of the passive appreciation that occurred thereafter. Correct?
Yes.
That's why, and the reason the court gave for choosing that valuation date is because, in her view, the wife had caused the case to go for a long time, unnecessarily, and she wasn't going to allow her to benefit from that. But it's not really a benefit, is it? I mean, if it's property she's entitled to.
Well, I think the point being is that this case should have been done back then. And the only reason that it is not is because of her delay tactic. So I don't think it's necessarily.
Therefore, then the logical extension of that is, therefore, the husband would be rewarded by getting all of the passive appreciation that occurred after the valuation date that the judge chose, which early on.
Yeah, yes, I understand what you're saying, Judge. Yeah. Let's see, the only other issue that I wanted to just quickly address is the denial for her attorney's fees. And again, that is also an abuse of discretion in the court. The court actually, to the opposite extreme, indicated that she would have awarded fees to the husband due to the factors in this case, but didn't, because the wife did not have the ability to pay. There was vexatious litigation in this case by her, not to mention that most of when she was most, if not all, I can't specify the amount, of the fees that she had accumulated when she had trial attorneys and appellate attorneys had been forgiven. So, so this court should affirm both that and all of the other issues.
Okay, thank you.
Thank you, Judge.
Mr. Grassley, you're up for rebuttal. You're muted, Mr. Grassley.
How many people would like to have a button for me?
All the time.
When counsel says that the remand was for a limited purpose, that's a stretch, Judge. The remand was for allow my client to put on her case that she was prevented from the first time. So that's one appeal that lasted for 1.5 years. That was not my client's frivolous delay tactic. That was a deprivation of her fundamental due process rights as found by this court in a unanimous opinion. And I would like to point out, because the only discussion about she knew she couldn't win an appeal that she filed was an appeal from the temporary denial of her temporary request for her request for temporary attorney's fees. And what she said was in her testimony on remand was, I was supposed to be allowed to testify on the second day, but it didn't happen. And so I couldn't win. And I read that and suggest that the court read that in connection with the fact that this is a pro se litigant who has learned a whole lot about being a lawyer by having gone through this long divorce process. The nunc-pro-tunc issue on the taxation, I'm really glad that counsel brought that up, because the reservation that caused the amendment that occurred in January of 2019 was to adjudicate a charging lien by one of the attorneys that my client had at the very beginning of the case, and which has not had since. This judge did not cite in the final judgment, and it's relevant to this whole theme of delay, is that this judge allowed one of those attorneys, Mr. Fluke, to have a charging lien, and my client's appellate counsel, Jesse Harrell, who handled the prior appeal in this case, and who on her brief wrote pro se or pro bono attorney. This court reversed that charging lien that Judge Polk ordered. It's your case 2D19258. So the last two, that was issued 3 months before the reversal in September of 2020 of this prior appeal. So this whole concept of, oh, my client caused all these delays, wants to rewrite history and ignore that the trial court's errors caused at least 1.5 years of delays in this case. That goes to the passive appreciation, which, Judge, you are correct. This judge is trying to punish my client, but I think more importantly is this judge says that she is upholding the party's 2009 agreement. And that agreement unequivocally holds that each party is entitled to half of the appreciation. And it's my position for my client that that appreciation should continue until a truly final judgment that does not get appealed is entered in this case. It is what it is. It's just dollar bills, but it's dollar bills that is legally, as a matter of law, belongs to my client. There's no justification here to say, well, this all happened way back in 2015, 2016, so we'll use the date of separation or the date of filing, because that's contrary to their agreement.
And am I correct? And and admittedly, I haven't necessarily dug deeply enough in this morass to see for myself. But
Good luck, Judge.
Am I correct in assuming that there was no distribution, actual physical separation of those accounts at the time of the original final judgment?
No,
so they continued in one account and continued to appreciate or depreciate.
The final judgment that we're here on calls for husband's counsel to arrange, I think, with an attorney named Lundy. And the only reason I remember that is I think he was a law school classmate.
Yeah, we know him down here. So anyway,
to prepare quadros.
Gotcha. And that was not effectuated because of the subsequent appellate.
I assume that, but I can't. There's nothing in the record that tells me.
Okay. All right.
Okay. The debt, credit card debt that's attributed, that's being picked up by the husband. The fundamental problem with that is that the judge assumed that all the credit card debt was because of my client's charges, which is not the case. The husband charged his attorney's fees on credit cards, including one that was a card in my client's name that she just discovered during discovery. Judge, I think my clock says I'm at the end. Is that correct? Whoops, you're muted, Judge.
You're 10 seconds shy.
Okay, I would like, as my last 10 seconds, to direct the court to my conclusion in my reply brief, because it specifies all the relief that I believe my client's entitled to. And I thank the court very much for its time and consideration.
Thank you both very much. I can't tell you how much we like interesting cases.
Yeah.
In order to leave our courtroom, you click the leave button in the lower right-hand corner of your Zoom screen, and you will be off.
Thank you, Judge.
Thank you.
Thank you, Your Honors.
Thanks very much. Okay, the court will be in recess for 10 minutes.